Good evening, everyone. Thank you very much for coming. I'm very pleased to see familiar faces that I haven't seen before. We've come a long way from Liberty Fighters Network side. Those of you who don't know as yet that we were the first ones in May 2020 which have challenged the lockdown regulations. I'm going to just refer to it as the lockdown regulations, but the correct wording should be the Disaster Management Act regulations. So since 2020 May, we've been challenging it. We've been successful with a court order on the 2nd of June, and according to us and many other academics who's specializing in real constitutional law agrees with us that our court order came into operation on the 24th of June 2020. And the government knew that, but they continued to slap a dead horse, because since the 24th of June 2020 there were no more Disaster Management Act regulations anymore. Poof. They were amending to regulations that were no longer there. So we had a couple of court cases in between, and we landed up in the Supreme Court of Appeal. And there, many people don't understand what happened there, and I was also recently challenged by a legal practitioner who thought that we were doing the wrong thing, and I've said, okay, just choose your live forum, and he chose Loving Life, and we had this one-to-one debate the one evening. Some of you might have seen it. Yusuf Ishmael was his name, an attorney from KZN. And many people afterwards said, no, Reyno, you definitely won the debate according to us. But it's not about winning or losing the argument. It's about having alternative options given to you, and not just a straight narrative that's forced onto you. So it's all about choices in life. That is true democracy. So if you've got a piece of cake and a piece of sausage, you've got the choice whether you want to eat the cake or the sausage. But don't just force the sausage down everyone's throat, because many people will not like the sausage. And that is typically what this whole lockdown and national state of disaster has brought onto us. It's the failure of government to recognize our constitutional rights of liberty and our freedom of choice, freedom of movement, freedom of expression, opinion, and then lately the right to decide for yourself what is good for your body, and not that that your employer at the end of the day enforces all these claimed vaccines onto us. And let me start off with just a interesting background. Hopefully most of you will know this, but it's important to have a background of where we've come from and where we are heading to. I've been a rogue litigant, as I call myself, since 1994. So it's 29 years that I was forced in defending and opposing and instituting court cases without having the diploma against my will. When we look at, let's say we go to the CCMA. The CCMA is a establishment by statute which was created in the Labour Relations Act specifically for the reason of alternative dispute resolution, meaning that it's there to settle and not to actually sort out a problem. It's just there to settle. So that is why roughly 90% plus of the cases going to the CCMA at the end of the day end up in a settlement, which means that the parties sit during the con-all process, conciliation process. They discuss the matter without prejudice to their rights, which means that they can say anything. They can even admit that they are guilty, but it cannot be held against them in future proceedings. So during this conciliation process, they suddenly say, okay, we'll give you 2 months' salary. Or they usually start with, we'll give you 1 month's salary. And then the employee says, I want 6 months' salary. And then they move towards 3 months settlement out of my experience most of the time. But I've also seen a decline in, it seems as if the norm has become a 1 month just to get rid of you. Now the CCMA, when you go there, I always say that the CCMA is there to protect the rights of the employer, not of the employee. Because who is benefited by it, really? It's the employer who's benefited by the CCMA process. The employer has already budgeted for a 3 month salary or so for a unscrupulous employee he wants to get rid of. So when he goes to the CCMA, he knows that, you know what, I can kick this guy out of my door without having a disciplinary. Yes, it is an unfair dismissal at the end of the day, but I'm just going to say, sorry, 3 months salary, there you go, out of the door. It is against the employee because the employee is coming to those negotiations with a very bad situation. He has lost his job. He doesn't have an income. He's got a family to feed. He knows that we've got the worst unemployment rate in the world. So getting a new job is basically a no-go. So when they go to a CCMA hearing, they are basically forced into a settlement because they don't have any other option. Because if they fight it, they know that the employer is going, if it's in his favor, the employer is going to take it to the labor court and it's going to become a nasty affair. And he's just going to wait and wait for his money that will probably never come. So in that respect, I don't like going to the CCMA. So if there is an alternative forum in which you can fight these mandatory vaccination policies, why don't have a second option, knowing what the first option and according to some the only option is? The advantage of Liberty Fighters Network is that because we are not members of the legal fraternity and we do have very decent legal practitioners like Advocate Sabelo there and numerous others. So it's bad to put all of the members of the legal fraternity in this under the same umbrella. But the problem is that when a matriculant decides that I want to go to university to become a lawyer one day, he goes to university with this great mind of, I'm going to change the world. I'm going to stand up and fight for the human rights of other people who are being oppressed. So that is my intention. But the moment when you come to a university, especially one that is one that you must physically attend, like University of Pretoria or the Western Cape or Potchefstroom or so forth, you start to be seen by others. And lecturers and professors are all in some sort of secret organizations that they always belong to, secret cliques. So the moment when a professor sees that you've got the potential of becoming a bright legal practitioner one day, you are being sourced on university level already and nurtured to become someone you never intended of being. And the moment when you leave and you got your diploma, your qualification, LLB, you go into a legal practice and you start working there as a candidate attorney. When he is admitted as an attorney or an advocate, by way of an application must physically be lodged to the High Court, and then the High Court says that you are now an admitted attorney or an admitted advocate. Only then they are advocates and attorneys. So then they are part of the court system. They are in fact officers of the court, meaning that they are obliged by the oath that they have taken to respect the court whichever way it goes. And that is where Liberty Fighters Network comes in. Because we are not legal practitioners, we've got this bad habit of irritating judges a lot. Today's hearing in the Equality Court, High Court, sitting in the High Court in Cape Town, the reason why I had to come specifically for this in an open court, I knew that if you are summoned to court in an open court, so literally almost 2,000 kilometers away, and the judge is insisting that it will be heard in open court on Tuesday, you must make sure you are there. It could be that it is a recusal related, because of the fact that beforehand I've basically, in no specific direct terms, I've told the judge that she was incompetent of being a judge. So I've written euphemistic letters to her to say that well, what you are trying to order and the process you are trying to follow is not in terms of the I'm just going to call it the Equality Act, and you need to actually do this and this, and judges don't like being told by a layperson what to do. So it eventually ended up today. I've told her, she said that the reason for this hearing was to attend to the recusal application. And then I wrote a letter back to her and said, you know what, I might not know the rules, but tell me under which rule and under which authority can you have us to come to court for a recusal application while there are none. There was no recusal application before court. It was just mentioned that if you continue with this action, you need to sort yourself out, otherwise we will be bringing an recusal application. But then she started forcing us, yes, she will await our recusal application, and I just answered her back and said, but we don't want to lodge an recusal application and you can't order us to. So what are you going to do about it? Are you going to recuse yourself mero moto, which means that from your own doing? Or are you just going to wait until we eventually bring an recusal application? And yeah, she didn't like that. So the point is that today she was, Dietmar was there with us in court, and she was, you could see that she was, her face, justice and dita, she was, you could see the red in her face. She was really on the point, and she was mentioning, strangely enough, I must say that there was no argument for this. So she just had a judgment. And so we just came to court to hear her judgment. And she started attacking me in that judgment, left, right and center. And I've got a habit of doing this because even the Supreme Court of Appeal has got an issue with me, and she made references of the Supreme Court of Appeal, and that I've said that they must stick their apologies and sorry. She did mention the word contemptuous, and I was just sitting there and saying, is this for real? Am I going through this for a second time, that I am being judged without having the right of arguing my case? Is this the way our judiciary is going to handle these affairs? It happened in Jacob Zuma's case in the Constitutional Court, where and his arguments were 100% on correct. When you go to court, there must be an appeal process. You cannot just go and say that you are sent to prison for an X number of months. But sorry, Mr. Ex-President, you don't have a right to appeal this because of the fact that we are the court of last instance, and this is where it was instituted. So when you go and read the judgment in the Jacob Zuma matter, two judges, Teron and Jafta, had descending judgments, meaning that it was a minority judgment, in which they perfectly said that this is not something to be dealt with by the court. This should be sent to the National Director of Public Prosecutions, and it should go in a criminal proceedings, where the accused ultimately have processes of appeal, and there are much better systems in which there can be investigation done, whether you are guilty or not. So this is exactly, I was put in, and references were made in the Supreme Court of Appeal to specifically the Jacob Zuma case, which was at that stage 2 days. It came out on the 29th of June, ours came out on the 2nd of June, and the CR17 judgment came out a day before, I think on the 27th of June. So Cyril Ramaphosa had everything in line to punish and do what he wants in that week, when the one after the other pro-Cyril Ramaphosa judgments came out. So I was, unfortunately, this judge had a reference to that, and she then she stopped it by saying, as a reason of this, and I cannot go on in this atmosphere, I am recusing myself. And when she said that, I thought, my good gosh, you just admitted that you were not independent and you were biased. Because those are the only reasons why you must recuse yourself at the end of the day from a case. So she has then, as a result, basically confirmed what we have been trying to do all the time, to prove over and over again that our judiciary is not at the point where it's supposed to be. Our judiciary, according to us, has been captured and is no longer independent. It is waiting for instructions from our very government. So when you've got this in a constitutional democracy where the main pillar, actually, the judiciary, has been put in a position that they can no longer function independently, then we know that we have lost our democracy and our liberties. So now we need to sit as people and society to say, what are we going to do about it? Are we going to sit and wait for our liberties, what we still have, to be totally taken from us, or are we going to make a stand? Liberty Fighters Network has always said from the very beginning that our moral and ethical values are not negotiable. You can do whatever you want, you can put $1 million on the table for us, and we will say, okay, thank you very much. These people just bribed us. Do you want something, some tips? That is the way that we are also approaching these mandatory vaccination policies that are coming our way. We are saying that we solely represent those who are sure that their moral and ethical values are not negotiable. They will not submit themselves to these candidate vaccines. Now the problem with the candidate with the so-called mandatory vaccination policies, number one, according to us, and you are more than welcome to go and do your own research always, go and confirm this yourself, go and ask others. We are from the view that there is no such thing as a mandatory vaccination policy. Number one, yes, we've got the court order, which we said has already came into operation on the 24th of June. So the so-called Consolidated Direction of the 11th of June, Government Notice 499, said specifically that, you There's no such thing in in that direction saying that you may implement a mandatory vaccination policy. It only refers to, number one, when a vaccine is available, number one, in the definition, and which has been approved and recommended by both the World Health Organization and SAHPRA, which is our regulatory authority for medicines. Only then this can happen. They even went so far to underline the definition in the regulations to make people aware of, remember this, on 2 instances in the direction. So number one, you cannot have a policy for something that's not there yet. If the first one is approved, formally approved and registered, yes, only then they may. But then we also say, okay, but there's another problem. What is a direction? Is it law? The mere fact that it was published in the Gazette, in the government Gazette, does it make it automatically law in South Africa? Let's use the example that if someone is publishing a notice of sale and execution of property in the government Gazette, does it become law? No, it's a notice. It's something that it's not necessary. There's some elements that need to be there when it qualifies as a law. Now, law, yes, I'm not going to go into the common law aspects. I know some of you are common law supporters. I'm not going to go in the common law. So I'm not going to go into the land, air and the water issues. But the fact is, in relation to what system we've got, a direction is not, you basically stop with legislation on the regulation level. So once the direction was issued, it was issued under the regulations, and what it says is it's a direction, meaning that there's a riglyn. It's guiding you in a direction, what you can or cannot do. And it never said that everyone must do the mandatory vaccination policy. It gave you the option, if you want to go that route, this is what you need to do. Full recognition of your constitutional rights, whether it's religion, bodily protection, whatever the case may be, full protection. The word exemption appears nowhere in that direction. So where these blue chip companies came to the you must apply for an exemption, oh shoot, I don't know which idiot thought about that. Because at the end of the day, the direction is merely a riglyn in which you can do it, but if you go the mandatory route, you need to have full recognition of all the rights. Then I've made mention where it also comes in with the national state of disaster. Let me also just give you background that after our Supreme Court of Appeal case, we thought, you know what how are we going to fight back? Because the Supreme Court of Appeal essentially now has made an order that the judgment of Davis, 2nd of June, is no longer valid. However, there are numerous of authority coming from both the Supreme Court of Appeal and the Constitutional Court saying that when the court did not have jurisdiction above others to hear a matter, meaning that the court was not entitled to hear or empowered to hear the case, any order that is made by such a court is null and void, and you don't even have to appeal it or ask for a rescission. It's automatically null and void. So then we said, you know what, this was also after a couple of letters to the president of the court, which just infuriated. She came out. We wanted to test her on. We would like you to give us a direction of how to proceed with a rescission application of an order of the appeal court, Supreme Court of Appeal, because the rules do not make any provision for it. Then she came back, I haven't thought about that yet. There was never such a process before. And then this is what she said in her directive: we may proceed as we deem fit. Okay. So we were sitting with a directive from the President of the Supreme Court of Appeal, in which she said, you may proceed in any way you deem fit. So we were thinking of, let's just create an order, and then we say that, well, on the authority of the President of the court, we are now making the order that this order is no more null and void or something. We wanted to go crazy on it, but then we said, no, let's just go back to basics. Why should we do anything about an order that was null and void from the beginning? We said that because of the fact that, yes, we did bring a formal recusal application on the Monday before the matter was heard on the Wednesday by the 5 Supreme Court of Appeal judges. That was a formal application before them. And those judges chose to skip it, ignore it as if it's not there, and they continued with the hearing, and we said, you may not continue with the hearing, you don't have the jurisdiction to continue with this hearing until you have dealt with the recusal application. And they said, okay, let's just, this Nafsa, who is a very decent, he is a very decent judge. He started saying, okay, Unterhalter, are you going to recuse yourself? Oh no, I'm not. Mbata, are you and he went down the line. Okay, no one of us are going to recuse ourselves, so we're going to proceed. That's how they dealt with it. But they never dealt with the merits, no arguments were thrown, nothing. So we said that we're not going to continue, everything is null and void. We're just going to sit back and be observing what is going on. So yes, they went on, and later on all this crap came out that we were contemptuous in the judgment. But strangely enough, in that judgment they said that Justice Davis was not authorized to deal with Level 3 Disaster Management Act regulations because it was not before the court at the hearing. It was not there at yet. So he has adjudicated something that happened after the hearing. Oh my word. The letter that I wrote to the president of the court saying that they must stick their apology in their arse happened after the hearing. So they basically said for Justice Davis's, it does not work like that, but for us it does work like that. So they've confused their own argument with themselves. These are 5 brilliant judges. They were really brilliant before COVID-19. But you could see that when we also went with the other part, we also challenged the national state of disaster, going to the Constitutional Court on 2 occasions. They have just said that there's no merits in our case and it's dismissed. So the first one, we said we knew each and every time that our arguments were spot on. And every single time the Minister of Kochta, Dlamini Zuma, chose not to answer to it. The law, the authority from the Constitutional Court says that if you are challenging regulations, for example, it is the responsibility of the government to prove. The onus of proof lies on them to prove that those regulations were constitutional and valid. We can just simply make the statement, take it to court, and they must then prove, oh no, you're wrong. But not once did that happen. So the Constitutional Court, when we challenged the national state of disaster, a very simple thing, and go and check this out for yourself. The meaning of a disaster in the Disaster Management Act. It specifically says that disaster, floods, whatever the case may be, natural disaster or event, and that those people who are affected by this disaster cannot deal with it themselves with their own capital, on their own resources, basically. Okay, now let's just see disaster. So that must be present. People cannot deal with it on their own way and on their own terms and resources. Number one, 90%, if not more, of these cases had medical aid, so they did make provision for themselves and they could deal with COVID-19. And even those who passed away, as they said, of COVID-19, they had funeral policies cover. So I'm in contact with the funeral industry associations as well, and according to them, they are not aware of one single COVID-19 pauper funeral since the national state of disaster started. So not even in one case did the government pay for that COVID-19 pauper burden. It means that the definition of disaster was never present. And then we've also discussed the way in which it was declared, the processes, the guidelines, nothing was followed. It was thumb-sucked. And then a very deadly one that we threw as argument from the very beginning, which Dr. Beata will confirm, hopefully. The ICD-10 code for COVID-19 only came into operation from the 1st of April. We went into lockdown on the 26th of March. So if the code for COVID was only there from the 1st of April, how did they know that there were 1,000 cases of COVID by the 26th of March? Actually, there was no way in which they could have determined it. No way. That was one massive lie. The moment when they went into lockdown, the disaster, declaration of the disaster, was the disaster. Because that is when all else started failing. We started losing our jobs, and people have just been pushed to go and test your thing. So yes, this is how they have been manipulating us from the very beginning. And so our challenge of the declaration of the national state of disaster went to the Constitutional Court, and we have, because we've done this now, you've been knowing Liberty Fighters Network for 2 odd years. We've been in the game, I've been in the game for 29 years already, but Liberty Fighters Network have been there for 5 years, and we have become known as putting traps for the judiciary. Things that we say in our court papers that they have to read and take into consideration, and we will immediately know by their action that they have not read the papers. And that was typically with our appeal regarding the declaration of the national state of disaster. We've put some traps there. I'm not going to go into the nitty-gritty there. And they've fallen for the trap. We know they've fallen for the trap. Hence the reason why we then, after they've dismissed it, we've brought a rescission application to say that you have made points of error. You have not done this and this and this and this. And once again, they have just, without asking us to proceed, they have just dismissed that case. So then we were put before what next? And we've done this also before with other matters concerning judicial corruption, and we've escalated it to the African Commission on Human and People's Rights. So yes, you will immediately say, well, African Union captured. So what's the use? What can they do? What can they do? When you go to section 232, 33, thereabouts of the Constitution, it deals with international agreements. So it basically says that an international agreement that has been ratified by the Parliament is law in the country. So both the African Charter, let's just work with the African Charter. The African Charter has been ratified by the Parliament, and it is law in South Africa. It specifically says in the beginning of the articles, it says that every state party, meaning Republic of South Africa, must make all their legislation in line with this, and there is no limitation clause like we've got in our Constitution, section 36, in the African Charter. So on local level, the government is protected by the Constitution because they're functioning within the parameters of the Constitution. They've got section 36 limitation clause, but the African Charter does not have that. So meaning that the moment when you can prove before the African Commission on Human and People's Rights that the state party has violated any one of the human rights enshrined in the African Charter, they are in contempt of the African Charter. Then the African Commission can institute several things. They can reprimand the country to come in line. They can ask for they can grant compensation. They can institute sanctions, and South Africa, the African continent, still have a lot of conservative African states, states where their moral and ethical values are not negotiable. They are not subscribing to the so-called New World Order. So you are sitting in the African Union, unlike the United Nations is, you screwed there. Because most Western countries force their beliefs onto you and you don't have anything to say. But in the African Union still, there's some sort of balance between those who subscribe to the COVID-19 narrative and those who don't. So even on the Commission itself, it's quite balanced. So if there is any international forum which can do something about what is going on, and it is affecting other state parties as well, we are the African Union is probably the only international forum who can come to the rescue of the people. And what we have seen that since October, when we have lodged our complaint before then, we've got confirmation that they are busy working on the case. We have indeed seen where we have expected numerous of increases in the measures. We've even expected the crystal ball professor Karim said the 2nd of December the fourth wave will hit us and last 75 days. Shucks, he was wrong. Thank you. But why was he wrong? He did so because he was already instructed a long time ago, this is what's going to happen. And why did it not happen? Because of the fact that the African Union became involved, whether you like it or not. So the moment when we've lodged this application, we specifically said that this application needs to be dealt with as a matter of urgency because it's also affecting the other countries in Africa's party states as well. So we have indeed seen that there is a decline in measures since October. We had a decent holidays, December, everything. And then even on the 1st of February, we did see a magnificent change, positive change in these regulations as well. Some people said, we're going to be taken to quarantine camps and isolation, but they haven't read what it used to be. And I've done a video on that to say that people relax. There are, if there is one message that I want to give to you and you can go out with it tonight, is that there are many positive things happening that you are not aware of. There are some things that I have made a gentleman's agreement not to divulge to any others, so which I can only tell you that the moment when that information is coming out, it's going to create a massive rift in the ANC, what we want. So a lot of things that are currently happening, just read between the lines. Read between the lines. We are not going the Australian, New Zealand route. We are not going there. We are more unified in South Africa than the mainstream media wants us to believe. They want to put negative small things in the media. Oh, 2 cases in the CCMA said that you may have mandatory, but they're forgetting about all the others. They're going with a certain narrative. They're not lying, the media, but they are lying because of not telling the other side. So in that sense, read between the lines. Many positive things are happening in front of your eyes, and let me say, the African Union is going to become much more busy than you will ever expect. We've lodged a bombshell there, and it's really making its turns now. So hopefully within a short period of time I'll be able to put on our group what is busy happening, but up to now, just hold on with your fears. Stop being afraid. The moment when you stop to be afraid, that is the best weapon against them. The moment when you start to say that we will not abide, that is a time when they lose their grip on you.
Can I just say something?
Yes.
We are not the only country where this has happened. You won the court case and the government was in contempt of court. They did not enforce the ruling that was made at court. The same thing happened in the court in Weimar, that's the south of Germany. The same thing happened when the Constitutional Court in Austria ruled the lockdown invalid and unconstitutional. And look at what's happening in Austria now. The government is completely ignoring. We are not the only ones. This is happening all over the world.
Okay, but what is the difference, and I'm coming back, what is the difference between them and Africa?
We have more people who say we will not comply.
Yes.
That's the difference.
We have, Africa is the only continent in the world who can rescue the entire world from this tyranny that's going on. And that is why we need to continue to fight our fight as we do. Because the European Union has been captured. The United Nations has been captured. So the forums whereby Austria and Germany can go to for help has been captured. So they know that the European Union will not help them at all, and that is why we are sitting in Africa. We are busy with a fact-finding mission to the Gambia, where the African Union Commission is sitting. We've heard already from very good sources that Cyril Ramaphosa has already sent his troops to Gambia to try and influence the commissioners there. So we've got the means, or we've got the not the backing, but we've got the capacity to go there ourselves as well and do something similar. So at the end of the day, we need to take hands with Africans. So we need to go out to other African countries who are feeling similar like we do, and we need to say that on a diplomatic point of view, will you stand with us if anything goes wrong, if we try to legitimately take over the country? Will you back us? So there will be diplomatic missions that we need to undertake. Those things are in the planning, and we will give you more information. But that is the hope. We are Africans, and we must start to be proud to be Africans.
The exemption route, you can ask exemption on constitutional grounds, on health, on belief and religious. Now, I always advise people against that, going that route, because I think it's a trap. But I want to come specifically to the issue of constitutional exemption. I picture a little diagram about the Constitution, where you have the people, you have the Constitution, and then you have government, right? What we're asking now in terms of this is that you've got to prove why your refusal to take the vaccine is actually constitutional. Everything gets inverted.
Yeah.
Right? What do you say?
Oh, but why go that route? If the creation of a mandatory policy is not valid in the first instance, why do you want to follow a route of an invalid process? You simply, from our perspective, we just simply tell our members who are ask us to do their cases for them, we just simply tell them we have taken the route of they first send a notice of a protected disclosure. Now, what does that mean? A protected disclosure is protected in terms of the Protected Disclosures Act of 2000, whereby you are telling your employer that he is committing an offense, or he is transgressing the law, or he is discriminating against you. But by just merely thinking of making such a policy already implies discrimination. Just take that into consideration firstly. So then secondly, you're making a protected disclosure, you're giving him 21 days to rectify this, and if he does not, or in that period while there's a dispute, you are protected by the Act of being disciplined or retrenched or whatever the case. You first need to deal with the dispute, sort it out, and then when both parties agree that you don't agree, only then they can go over to disciplinary or retrenchment or whatever. But until that point, you are protected. They may not do any of that. So we are using the protected disclosure letter, sending off to them, giving them 21 days, and they usually don't comply, or they say, oh no, there's no protected disclosure made. But in terms of the Act, it's not for them to decide. This is all these things, taking law into your own hands have become an everyday thing these days. People are just saying, you know what, if it started off with yes, it was always a problem with illegal evictions, but if the landlord just says, yeah, you owing me, giving you 48 hours, otherwise I'm kicking you out, then they can come in, the police will do nothing, illegal eviction, no criminal cases, exactly the same with this. They are getting away with this because they know. Why do they know this? Why are they getting away? Because those employers know, number one, they've got the money to get any legal team they desire. Number two, we will go to the CCMA with this. We've got the pocket, 3 months salary in our pocket, and that will be our way out. So we can take law into our own hands and we will get away with this. But now with Liberty Fighters Network's approach of not going the CCMA route, but going the Equality Court route, the Labour Relations Act says that the Labour Court and the High Court has got concurrent jurisdiction over discrimination cases. And then further, the Basic Conditions of Employment Act says that the High Court has got concurrent jurisdiction with the Labour Court concerning any dispute relating to an employment contract. So it says there. So if you utilize the High Court sitting as an equality court, you've got the High Court connected to the equality court concept, and then you can send it off based on the protected disclosure. You can send it off to say they have retaliated against me, an occupational detriment was committed against me. That is what it's called in the Act, and for that reason, it was based on discrimination against me as a member of the identifiable new group, which is a group not subscribing to the COVID-19 narrative and have chosen to be not vaccinated or getting tested. That is an identifiable group in terms of the Equality Act. And then once you have stated that correctly, you can then immediately go over to the Equality Court, and that process is so much better. Anyone can represent you in the Equality Court, and as a norm, each party pays its own cost. So there's no risk of, unless you were vexatious or frivolous, there's no risk that you're going to be punished with legal costs there. So when the worst case thing that can happen is that the court is going to say, sorry, I don't agree with you that this matter is supposed to be in the Labour Court. But then you ask the court to refer the matter to the CCMA, and then in terms of the Equality Act, the CCMA must report back to the Equality Court. So there's a way in which it can go out of the slipstream and back, and if it goes back to say that, sorry, we can't help it, the Equality Court must hear the case. So there's more flexibility in the Equality Court at the end of the day than with the Labour Court. With the Labour Court, you cannot be represented by anyone else. In the CCMA, you can only be represented by a fellow employee or a member of the trade union. So a legal practitioner may represent you if the commissioner decides that he may. But in most of the cases that I'm aware of, that legal practitioners as a general rule is not allowed. So they usually also coach the employee, and the employee must in any case do the case themselves. But that is sort of the problem there is the CCMA, as I've said, is a forum of settlement. When you settle there and you write your name, your signature on that settlement, it's over for you. You cannot go and try and get your other millions from your employer. So that's the end of the case. it can be rescinded and it can be reviewed under certain circumstances. In terms of the Employment Equity Act, a CCMA judgment can be appealed. That's the only one. Sibella, I think that's the only one, isn't it? Okay.